I see we have already 2 minutes past for
Okay.
my time. Let's start the webinar because there is really a lot what to talk about. And the webinar, the title is EU Customs Law News, the updates. Our goal was to overview 1 month updates, but the area is so complex and so broad that we narrowed it a little bit down and focused on certain areas. So I'm Enrika Naujoke, CEO of Customs Clear, and today I'm joined by Buckley, who is the chair of Customs Knowledge Institute. And by the way, Customs Knowledge Institute will soon change the title to Customs Knowledge Community, and you and all the customs practitioners are invited to join the community. The topic of today is very relevant, and yesterday we had a very interesting discussion, which is recorded in a free podcast for you to access, where it was emphasized that today we live in times of unprecedented complexity, that customs area has never been so complex as it is today. The podcast, all the slides will be disseminated after the webinar, and on the slides you can click, the links are active, and the podcast is free, so you can listen. It was attended by Buckley, who moderated and shared his views, also by Frank Heyman, who is Counselor Customs Permanent Representation of the Netherlands to the EU, and also by Professor Hans-Michael Wolfgang, who is the Director of Customs and International Trade Law Academy at the University of Münster in Germany. And at that podcast, it was not only mentioned that the complexity is unprecedented, but also Frank Heyman said that customs enforces more than 340 regulations, and the number is growing. And Tony today commented to me that, in fact, he thinks that considering all the international sanctions laws, the number is much higher. We will see. And one interesting point that was also mentioned during this conversation, which is recorded, that businesses still do not fully understand the complexity of laws. So let me start not directly with the overview of the EU laws, but to give and to discuss with you. Also, please share in chat your views, your opinions, as well the aspects of the complexity. One of the important aspects is that when we are talking about EU law news, we cannot take just EU law. EU law is placed in the context of global laws, WTO, WCO laws, in the context of international laws, the agreements, for example, free trade agreements, and it is also extended via the national laws and regulations. So we cannot pick a rule or a law out of the context and analyze it. We need to have the full view. So to start with, reading the law is not the right approach. To start with, understanding the full view is the right approach. Then the other complexity is that we not only have the law that I mentioned, but we also have laws that have extraterritorial effect. For example, the United States export control regulations, they have effect in the EU on the exporters who possess United States origin goods. And at the same time, EU has released blocking regulations saying that you cannot apply the United States laws, so the exporters are trapped between two contradicting regulations, and it is a huge complexity. Also, we have the interesting situation with Northern Ireland, where laws of the EU and of the United Kingdom customs laws apply. And we also have law in the title of case law, so the courts provide their interpretation, and especially the European Court of Justice how to interpret and how to apply in practice certain rules. And here one example that sometimes for those interpretations you can wait 14 years, so long can dispute in the courts take, and this particular case was worth 3 million euros, and the court's interpretation was not in favor of the company, the warehouse keeper. It is about the suspension of taxes. The further complexity. So we have discussed the hard law. Besides the hard law, we have soft law. We have opinions, guidelines, commentaries, communications, explanatory notes, and various other documents. One can think, okay, this is soft law, that means non-binding law, we can disregard it. It's not true. European Court of Justice has clarified that the soft law cannot be disregarded because it aims to harmonize the implementation of EU laws. Therefore, it must be taken in consideration. And in fact, in practice, this means that soft law has the effect of hard law. And for those who are wondering what communications mean, so there is an article explaining what is communication, and you can read it by clicking on this link. Further complexity, we have discussed hard law and soft law. There is another tier of laws, customs law and non-customs law. So we deal with sanitary, phytosanitary regulations, with carbon border adjustment mechanism, REACH regulations, deforestation law, forced labor law is upcoming, and many other regulations, which show how broad the customs field has become, how many laws are enforced, or in how many laws customs has a role to play, and the customs specialists need to know that as well. Further complexity, and this is the final one I would like to draw your attention, is that the laws are constantly changing. We will discuss this later on overviewing the EU law news changes, but there is also a major change ongoing in the EU customs reform. We can see this and follow by the developments of the customs declaration. It went from paper to digital and to systems, and alongside the customs declaration, the legislation has changed. We went from community customs code to the union customs code, which implementation is still ongoing. We don't have all the systems that are set out in the union customs code implemented yet. But this year, a new draft customs code was announced, repealing the Union Customs Code and setting new rules. So some rules are taken over from the UCC, but there are major changes as well, such as the EU Customs Authority, EU Customs Data Hub, Trust and Check Trader status, which will replace the EU status. So what does it mean for customs practitioners? That we must know what is changing, and we must plan for these constant changes. We must stay on top of the news. To summarize the complexity field, we discussed that it is unprecedented, that we have 348 regulation and the number is growing, that there is hierarchy of rules that we must take into account, that the laws can be extraterritorial, that there are territories where several falling under several jurisdictions, that we have case law, that we have soft law and hard law, customs law plus non-customs law, and the constant change is there as well. And the list is not final. We can discuss, for example, how Union Customs Code is interpreted in the member states, and we will find 27 interpretations, or we can go into the e-commerce topic, which is also a broad and evolving one as well. So our survey showed, we did a survey in Lithuania, that 90% of customs practitioners that we surveyed often or very often they feel overwhelmed with information. So that means that it's hard for them to follow the changes, and accordingly for the company to stay compliant with the constantly changing laws. And as I'm talking about changes, let's go to our major topic, the EU law updates and what was happening in the past 4 weeks. So every weekend I'm reviewing the changes and preparing the EU law news that are published on Customs Clear and the Customs Compliance and Risk Management Journal. Considering the news for this webinar, you will see there are many of them. And by the way, we will send you after the webinar not only the slides, but the EU law news for October, November, so that you can read them thoroughly. So first of all, I was optimistic. I thought I will group them into the areas and cover all of them. Then I realized that it is not possible. So I structured them into areas and picked some major areas to present to you what has changed and how significant the changes are. And once again, I cover only 4 weeks, calendar week 42 till calendar week 45. So the areas that I picked are the 3 classic ones: classification, valuation, origin. I would also like to draw your attention to tariff suspension, which is an option that is not known by some of the companies in the EU. Also, we will take a look at the new field, the carbon border adjustment mechanism. We will shortly discuss IT news in the technology, how it's developing, and take a look at the case law. And then Tony will take over and he will go deep into international sanctions area, which is related also a bit with export controls. So the first area that I picked, and there are major changes, is classification. And everybody knows that new combined nomenclature 2024 has been released. Not many changes, but all the companies importing and exporting goods must check whether the changes hasn't impacted their goods, whether the commodity code hasn't changed or information related to it. On Customs Clear, we are preparing an article and it will be published soon about those changes. Another change is communication was released, in which it is set out that customs authorities shall revoke decisions relating to binding information from this day, the publication of communication, if they become incompatible with the interpretation of the customs nomenclature as a result of the following international measures, opinions, and so on. There is the list of them. It's a significant change, and those companies who have applied and who have valid binding tariff informations should read this communication, because around 80 binding informations became invalid due to these changes. So take a look at this. Then we have numerous classification regulations, only in 4 weeks, and so many. It shows how complex the area is and how difficult it is to classify the goods. For me, most interesting were these medical filters and blades for glass scrapers. Why? Because these are parts and accessories, an area of constant discussions and changes. And definition is always a little bit uncertain. Then new technology, vlogging kit with ring lights, was classified, and you see the picture on the screen. This classification regulation is interesting because the general interpretation rule 3C applies. So when you have a product consisting of the parts which don't give a main characteristic to the project, you need to classify under the commodity code which is the lowest in the sequence. So this rule was applied here. Then we have a regulation on footwear, whether these are shoes for sports, you see a picture here, or whether it is a leisure footwear. And also we see that combined nomenclature explanatory notes were amended to subheading this one. So these changes are related. Then a product was classified under natural polymers and modified natural polymers. And it's interesting to see that 3 commodity codes were considered in this regulation, and decision came here. And also one very interesting case is red tea case, rooibos tea case, there was classification regulation classifying the rooibos tea, the red tea, under this code. However, it is now repealed, and the red tea must be classified under this code. Why? Because the Harmonized System Committee of the WCO has issued classification opinion, and in that opinion, the good is classified under this new code. So the EU regulations are repealed to adjust EU law to the global law as in the hierarchy, as we were talking at the beginning. Moving from classification to origin and valuation, it is important to emphasize that classification is closely related to the origin of goods, because the product-specific rules set out in free trade agreements are bound to the commodity codes, to the HS codes of the goods. And when the agreements are done, they are done based on the harmonized system version, which is valid that year, right? And here is an article which emphasizes how complex the area is. In this article, the author, Anna Gaik, says that European Union has many free trade agreements, and we can find that the free trade agreements, some are based on the HS version 96, some on 2002, and so on. So HS is changing every 5 years, and various HS versions are used in free trade agreements. So to determine the correct rule for your product, you must trace back the changes of the commodity code of your product, and only then to find out what rule applies. So a very complex area, and as you see, the news is that EU Central America Association, the agreement was updated to reflect the HS 2022. Then further news related to origin that you can find already published the value limits expressed in euro for Chile, Colombia, Ecuador, Peru, Korea, and Vietnam for the next year. And for those who are dealing with, who are involved in the EU-UK trade, there is an EU position published on the rules of origin. So this is a really area where many disputes arise, and EU disagrees with UK origin interpretations. So EU position is, and both parties are working on the paper how to deal with these issues. So if you are involved, it will be valuable for you to read. And finally, area valuation. Only one news, but very important. So around 60–70% of the global trade is trade or shipment of goods happens between related companies. So, and transfer pricing rules apply, and they are really complex. So now EU plans to simplify them to make more transparent. And a new EU transfer pricing rules are proposed. So you will find news on this as well. Next topic, next area is tariff suspension, and as I mentioned, it is still area that not all the manufacturers know. The essence of tariff suspension is that if you import goods which are subject to duty, for example, 10%, 6%, or whatever, and you can find similar goods here in the EU, you can apply to European Commission for tariff suspension. And it doesn't apply to a certain products from various areas can use this possibility. And European Commission announces 2 rounds per year, and there is a news that new round was announced. And you can read more about the opportunities in this one article, in which it is emphasized that in one member state, in Lithuania, in 1 year, thanks to the tariff suspensions, the importer saved more than 5 million euros. So it can be significant in some sectors. The other area that I picked is CBAM. What changes do we have there in the course of the month? The carbon border adjustment mechanism. It is relevant only for certain sectors, but please keep in mind that in the future the sectors will be expanded, new goods will be added. So hearing and listening about that is useful for everybody, because sustainability and environment, the topics are of growing importance and of growing regulation as well. So currently, cement, fertilizers, steel, electricity, and few other sectors are impacted. And there were updates of communication template for installations, of guidance document, and also of user manual for declarants of transitional CBAM registry. I highlighted these titles. It's about soft law, right? So therefore, the various titles are of interest to see. And to consider, I just would like to give one more thought, that we are talking from EU perspective, from importers, exporters, but there are EU laws that highly impact companies in the third countries. And for example, if the manufacturer in third country works in the sector that falls under CBAM regulation, and the manufacturer is in a very competitive market, that means the manufacturers are fighting for the importers in the EU, fighting to sell the goods, they must really go into the CBAM regulation and to understand the EU law to deliver the EU importer with quality data and quality information required under this regulation. And the other topic that I invite you to consider is the sustainability itself, because more regulations are coming out, and more all the companies will be impacted. So here is a link where you can find the definition of sustainability and consider it. The next area that I picked is a very exciting one, the technology. So we shortly touched the customs data hub, the future technology that will be developed by in the EU, and the national systems that currently our customs are working on will become irrelevant. So there will be one EU system in use. But we also said that the Union Customs Code is still in progress in implementation, and systems are still being implemented. So what we see from the EU law news from the 4 weeks, that there is information that TTL, the proofs of union status, are going electronic in all member states. Currently they are electronic, not yet in all, as of 1st March 2024. From the news, we also learned that WCO is working on electronic ATA carnet, and it should be in place worldwide by 2027. And we also learned that EU has made agreements with Korea and Japan on digital trade or cross-border data flows, which in effect both are about electronic exchange of data. And one more very important news is about centralized clearance. Centralized clearance is of high importance to many companies importing and exporting who have their affiliates in various member states and who want to centralize clearance. And now also CBAM comes into consideration, because besides customs declarations, the CBAM declarations will be due, and companies want to centralize them. So this is the solution which could be of help and to be looked at. And in Ireland, the system will go live in June 2024, if all goes as planned. Finally, the case law, the last area that I picked for the overview. The case law of these 4 weeks, we see the European Court of Justice has made 3 decisions. One is about import VAT, about the VAT taxable base of goods upon importation. and transport services. This one law is not a case law or decision of the European Court of Justice is not an easy read. So I've tried to understand what was clarified, couldn't, and Mark Robotham explained in an article, provided some clarity, but still it leaves you in confusion. So not the best example of the legislation, but yeah, we have these cases as well. Then we have the case that I already showed in the previous slide about the suspension of taxes in warehouses and the risks related with that. A very important case if you are dealing with tax suspension in general, be it customs warehouse, be it transit or inward processing. Read it, what can happen. And the third judgment is very interesting one and a nice one for the company. So you probably know, or somebody maybe are affected by the EU and United States tariff war. And the tariffs are imposed on some products from the United States. And here company Zippo appealed against the EU and has won the case, and regulation imposing tariffs on a certain product was annulled. Finally, the topic that Tony will talk about, international sanctions and also export controls. There were two major news. That one, that in the EU, we have the sanction good lists not only on EU level or export control lists, but also on national level. So the European Commission tries to help businesses and to consolidate them to provide more visibility. And the other news is about the circumvention of sanctions. European Commission made of goods that are subject to circumvention or at risk of circumvention to help with compliance. So finally, before handing over to Tony and to his topic, I would like shortly to answer the question that probably many of you have. How can we deal with the complexity, right? We have overviewed a part of it, and there is still a lot to be discussed about. Professor Wolfgang in the podcast said that the key to managing complexity is knowledge. We as knowledge providers, but we are also learners, constant learners, we deal with the question how to deliver the complex knowledge and how to take in the complex knowledge. The suggestion that we have at the Customs Knowledge Institute and at the Customs Clear, that we must follow the way of customs development, which moved from paper to digital and is moving now to systems, and also to think of systematic approach to knowledge to create some kind of systems that help people to consume and to intake the knowledge. So currently on Customs Clear, we have knowledge in the form of online articles and videos, as you have seen in the slides, but by request from the readers and watchers, we have also created together with Customs Knowledge Institute the continuous professional development program, which is human-to-human system based on regular meetings, based on guided learning and discussions, and you can find more information here. So CPD program participants have access to all the articles and videos that I showed you and many more. That's it from my side. Thank you. If you would have questions, you are always welcome to contact me by this email. So thank you, Tony, and over to you. And I see we have in chat some notes. I will read them later.
We have, I think they have mostly been answered at this point, but nevertheless, it's good to see the participation and the interest. So I'm going to talk about a subset, if you like, of what Enrika has discussed. She has discussed the broad canvas that happens in 1 month the month of October in the EU, and it's immensely complex, frighteningly so, actually. And of course, we all in the customs business tend to focus on our little slice of it in order to contain the knowledge requirements. As Enrika has said, we need to have an awareness of the broad canvas, the great spread of international customs law, but most businesses in particular tend to focus on their own products, and as such they can take comfort, as it were, that as long as they don't change what they're doing, then perhaps they're safe. Well, this practice actually encouraged me to look at EU sanctions, because that is an area where safety is very difficult to get, and where exposure to unexpected impacts of law, um, that exposure is always there. Particularly where we are now, where sanctions packages are increasing and being amended and changed on a weekly or even on a daily basis. As Enrika pointed out there, in the past week or two, national prohibitions have been published, and the EU has authorized member states to impose export controls on goods restricted by other member states, provided they are within the EU overall package, as it were, or provided the EU places them on a consolidated list. So that means that even the national authorities are not sure from time to time as to what goods are sanctioned and what goods may be sanctioned in the future. So a shifting canvas. Sanctions are not new. Sanctions of the present extent and depth are, however, unusual. And they are, of course, generated by the situation in the Ukraine. And of course, even thinking about imposing sanctions in relation to Ukraine takes the EU since 2014 into the area of imposing restrictions on a region within a country rather than an entire country. And of course, that creates even more complexity than would normally apply. Sanctions are interesting because they cover so many different sectors of activity, and because they are politically and perhaps economically generated, and as such are devised and derived not primarily with customs law in mind, but more with a political objective, which customs is then, as it were, adapted to fit. There's another really special characteristic of sanctions, which is that sanctions are capable of imposing an obligation of result on economic operators. That means that the operator is told that you must not allow these goods or those services to reach that country, or you may not use goods which have originated in that country. It doesn't say precisely how you do it. For example, the Union Customs Code is full of procedures, and particularly the Implementing Act and the Delegated Act associated with the Union Customs Code are full of detailed procedures saying you must do this, and you must provide evidence in this format and that format, and then you're compliant. Sanctions do not specify in that detail at all. They simply say this trade is prohibited. The result is you must assure yourself that nothing that you do could be interpreted as breaching the sanctions. And this places an obligation on the economic operator to prove their innocence in the event that a breach of sanctions occurs. So if a breach of sanctions occurs, the all of the economic operators in that supply chain are potentially subject to penalty. And each one involved in that supply chain must show that they were unknowingly involved, and that they did everything they reasonably could to avoid being involved in circumvention of the sanctions. And this places the burden of proof on the economic operator rather than on the customs authority. It's a very unusual imposition, and it makes sanctions dangerous from the point of view of an economic operator. We are speaking, Enrika and I, today in the context of knowledge and how to have the knowledge you need to perform. And so I'm going to concentrate for the next while on just where is the knowledge, how much of it is there, and how do you take reasonable steps to be well informed. To start with, I just want to show you the map of EU sanctions. If I can get this link to work. Yes, something is happening. I must stop share and do a new share, I think. Yeah. So this map shows the sanctions in place imposed by the European Union. And I imagine that, like me, when I first saw this map, you'd be a little surprised that there are so many areas of EU sanctions. As you can see, it goes Libya, Niger, Mali, over to Guinea, Venezuela, Nicaragua, Iran, Iraq, of course, Afghanistan, Myanmar, North Korea. Well, we would expect that one. Then, of course, you have Russia, you have Belarus, and you have areas of Ukraine. So they're huge, and you also have Bosnia and Herzegovina in Europe. You have Turkey, Syria, and so on. So the range extends very widely. And this table underneath the map gives a helpful guide and an indication of the extent of the restrictive measures or sanctions. So you see you have the different symbols. For Belarus, you have arms, of course. You have freezing of assets, the picture of a snowflake. You have dual-use goods. And then you have all of this particular symbol means financial restrictions. And you have several of those. You have air travel restrictions. You have prohibition on the admission of people. You have a ban on items that can be used for repression. And then you have goods of various sorts, the aviation or space industry, export goods or technology, and you have several, this is prohibition on goods with this package. And you have several of those again, 1, 2, 3, 4 of those. You have, this is a prohibition on firearms. And here you have mineral products. And this is goods, tobacco products are prohibited. So that's Belarus. There's a huge range of prohibitions there. On the different countries, the range of prohibitions may be more specific. It may be a more surgical approach where very few are imposed. The sanctions on cyber attacks is an interesting one. This is a series of sanctions that has been agreed against people who are involved in cyber attacks, whoever or wherever they may be. And there is the power to seize and freeze their assets, and there is the prohibition or restriction on their admission. Then we have North Korea, which, as you can see, has quite a list of prohibitions, Congo and so on. And we come down to Russia, which we'll be mainly talking about along with Belarus. And as you can see, many, many regulations restricting just about everything, really. And you have attached files which give you, just to get back up to the title, a list of the prohibitions, the legal acts, and guidance documents. So this page is a very interesting one. And it gives you, if you have the patience to read through everything, it gives you the basic outline of all of EU sanctions. And as I say, there are a lot of them. So what we're dealing with sanctions then is, as Enrika mentioned, and indeed Frank Hyman yesterday made the point, 348 EU restrictions by way of regulation. In fact, I have an idea that the list is considerably longer than that. These are the main regulations bearing on Russia and Belarus. When I say the main regulations, these are in turn backed up by implementing regulations at EU level, of which there are, I think, about 20, and then also by national regulations imposed by national authorities. It's a daunting list to anybody who wants to find out about sanctions. You bring him to this page and say, read all of those and I'll see you in, I don't know, a month. It's a huge amount of information. So you need some guidance on it. You have this basic regulation here, 765 of 2006. And in fact, every time you hear that the EU has introduced a new package of measures on Russia and Belarus, it's usually by amendment of Article 1 or 2 of this regulation, 765 of 2006. So that's definitely worth a look. For now, I want to show you this notice to economic operators because it is pretty stark in its implications. And again, I'm afraid I'm not as high tech as some other presenters. I must stop share and start share when I switch screens. With this notice, that's it. That's the entirety of it. It's just one page. But it is informing operators, importers, and exporters, which includes, of course, transit operators as well, because the sanctions on Russia and Belarus also encompass transit, and also encompass financial services, which may be associated with trade, and we'll come to those in a moment. But these measures ban the direct or indirect import or export and prohibit the participation knowingly, also intentionally, in activities to circumvent these prohibitions. And they establish member states shall apply sanctions to infringements of these regulations. So it's up to each member state to devise its own suite of penalties and punishments for circumvention. Economic operators are advised to take adequate due diligence measures, and I'll come to that in a little while as to what does that mean? What's due diligence? And it deals with exports, where exports can be diverted towards Russia and Belarus, and imports, where the goods concerned can be diverted to the EU from Russia and Belarus. It gives some examples here of due diligence. And then it says, operators should take into account that in order to prevent circumvention, EU customs authorities may carry out more strict controls and may also request conclusive evidence that the concerned goods are not imported from or exported to, which means that national authorities may impose tests, checks, and so on, which are not envisaged in the Union Customs Code, but which are justified by these sanctions regulations. And it's in its simplicity and in its scope, I think this notice is worrying for anybody involved in import and export. And you would, of course, be seeking further information, further detail. What does this mean? The answer isn't always easy to get. The frequently asked questions on sanctions against Russia is a very useful page published by the European Union, or the European Commission, and it clarifies much of the application or the applicability of the law. However, the scope is so huge. We'll see a list of products later that is encompassed. The scope is so huge that no one web page can give you all of the information that you need. So the knowledge challenges, your challenges as an economic operator or as somebody perhaps advising a company as to their compliance with sanctions regulations. Well, your challenges are national authorities may impose stricter controls. The link there given is actually to a report from Lithuania, where the parliament passed a law in May restricting certain movement of people from the Ukraine and also restricting the import and export of the Ukrainian currency, the hryvnia, I think. Yeah. And that's an example of where a national initiative was taken. It applies to all economic sectors, including legal, financial, transport, manufacturing, distribution, you name it. It applies across the board. In certain countries, in Ireland, for example, the most active enforcement of the sanctions relates to financial transactions, because our dealings with Russia in particular would mostly be in financial instruments, savings, investments, shareholdings, things like that. Then in other countries, as I know from speaking to Enrika, in Lithuania, the enforcement is very heavily on the movement of goods, including the transit of goods between Russia and Kaliningrad, for which there is in fact a special regulation. So the emphasis varies between member states. There are efforts to coordinate. I won't go into that link. It's a paper published by the Parliament, the European Parliament, on the coordination of enforcement of the sanctions. Much of the obligation, if you're concerned with trade and customs, much of the obligation consists of knowing which products require export licenses, what imports require additional information on supply chain, because if you're importing goods, the customs under these sanctions regulations are entitled to ask you to give an undertaking that nowhere in the creation of these goods was there an involvement from Russia, Belarus, or any of the free circulation countries with whom Russia and Belarus are associated. That requires a lot of information. And you need to know which products are covered by these regulations. But it may be difficult to determine that in advance. Just to take then, if you get it wrong, what's the story? Well, there is a provision. I've lifted this from an Irish statutory instrument or regulation. But this provision or something very like it applies in every country in the EU. And what it says is that where an offence is committed by a body corporate, that is a company or other corporate structure, then any person being a director, manager, secretary, or other officer of the body or a person who was purporting to act in such a capacity, that person is also guilty of an offence and may be punished personally. So directors of companies have a personal liability in the event of a breach of sanctions law. What does that mean? Well, summary conviction, which in Ireland means a minor offence, which is brought to a local court, a district court, then a fine, a relatively small fine, perhaps up to 5,000 euros or 10,000 euros may be applied, and up to 12 months imprisonment. Conviction on indictment, which means it's a case to be heard by jury in a higher court, then the fine raises to 500,000 euros and up to 3 years imprisonment. So quite serious penalty. But in addition to that, of course, you have the seizure of goods, you have customs penalties under the customs code, such as fines, withdrawal of authorizations or prosecutions under customs law, as opposed to sanctions regulations. That may happen also. So there's quite a lot involved. And in fact, countries in Europe and the EU generally are taking these sanctions so seriously that I don't think it would be an exaggeration to say that being found in serious breach of sanctions would threaten the future of any company found guilty. And because the offences relate to outcomes, just to repeat that point, in other words, the issue is whether sanctions have in fact been circumvented. If that is shown, that the sanctions have been breached, then the economic operator must show that they could not have been aware of the breach. In other words, not just that they didn't know, but also that they took all reasonable steps to ensure that the supply chain or transaction was in fact compliant. And this is what is meant by due diligence. Those advice notes, that notice that I showed you from the European Commission, is evidence, if it is ever required, that the European Commission warned economic operators that they must apply due diligence. Excuse me. And that brings us to what is due diligence, and how do you apply it? But first, I want to show you some material here on the information side. There is in most countries a central competent authority that, as it were, draws together all of the national rules. And again here, please bear with me while I just quickly flick here. In Ireland, it's the Department of Enterprise, Trade and Employment, and it gives a huge number of sources of further information. And I would hope that in whichever country you're in, you will also have a central website like this that summarizes the trade sanctions from, usually it's the ministry that is overseeing this. It could be the Ministry of Foreign Affairs. In Ireland's case, it's the Ministry of Enterprise, Trade and Employment. A general site like this is a very good place to start in seeking information, because they give you links to the other sources. One thing, the European Commission also gives good guidance, which you can access through that link at your leisure. I want to show you this manual, which is the Customs Authority. And the Customs Authority, of course, is the most relevant to most of us involved in customs. And this is the manual in Ireland, the manual on EU sanctions in response to the situation in Ukraine. And this is not going to take very long, because I just want to show you two things. First of all, it gives you more references to the individual regulations. But look at the grey boxes. The grey boxes are where the information on what action is customs to take. What action will customs take to enforce these sanctions? It's redacted. Action to be taken in Russia, redacted. Action to be taken in Belarus, redacted. So you're left then with just circumvention, which is general information, as you've seen. The risk information form, which is how customs will assess risky goods and risky behaviors, redacted. What they do give is a list of all the chapters of the HS code, which or the HS system, which are prohibited. And it goes on, many pages. So as a point of reference to see if your goods are restricted, the manual is useful for that. But as to giving information on what customs expects, how they will approach compliance, what do they expect traders to do, it's not there. So considerable variation in practice between member states, and the extent of the sanctions makes it really difficult to have a comprehensive understanding. So again, we're back to where I started, which was that in coping with this enormous flood of information on EU law and customs law, most companies have to restrict their knowledge to the business that is directly relevant to them. And as I've explained in the case of sanctions, because of their generality and the fact that they cross so many sectors, may not always be clear just what is relevant to you. Due diligence then, taking out insurance, as it were. It's in the form of an internal compliance program, or ICP. And the EU published a recommendation, which is there, setting out in detail what it expects of an internal compliance program. And my advice to you today would be, if you want to protect yourself against unpleasant surprises in relation to sanctions, you set up an internal compliance program formally. It will require new standard operating practices within a company and close monitoring to ensure they're implemented in practice. And you need detailed information about the supply chain, export, import, and transit. And again, there I'm just noting the special provisions for transit between Russia and Kaliningrad across Lithuania, and the fact that national authorities have the authority now to check goods in transit if they suspect that they are following a route other than what is officially reported. You may require to get undertakings from your suppliers and from your purchasers as to the ultimate origin or destination of goods. This is recommended in the recommendation. It can be very difficult to do. And then there is the quality of those. There are, of course, the red flags, as it were, that the EU says what you should watch out for as a warning signal. But overall, I think what I'm saying is that, first of all, it's very difficult to keep up to date with EU law, and Enrika has made that very clear. Access to a website like Customs Clear, and indeed looking at the various podcasts and articles produced by CKI, is a good way to at least stay in touch with the information. You will need to focus on issues that are of particular concern to yourself. But overall, I think what I would be recommending, particularly where sanctions are concerned, is that you use an excess of caution, as it were. That you really take what may seem to be excessive care. Because if anything goes wrong, and it may be something that is done by someone who is not directly connected to you, But if you're part of that chain, you then have to be able to prove that you took all reasonable steps to comply. It's an extraordinary body of law, extraordinarily powerful, extraordinarily dangerous for trading companies. Thank you for your attention. And any comments in the chat now we, I think, may deal with.
So thank you very much, Tony. I hope the attendees have got insights, at least one for them to consider and to, for themselves, and also in practice of the company. So regarding the chat, there are no questions to be answered, and we are just in time to finish our webinar. And we hope to meet you on various occasions and in various instances, and also in the future events. And if you have questions, please also feel free to reach out me or Tony, and we are always very happy to discuss, especially knowledge-related issues and how we can solve them. So thank you very much. And
thank you, Enrika.
Thank you, Tony.
It's very
and
good.
Thank you, everybody. Have a nice evening or day, depending on where you are.